If you can't score well on the logic test, you don't get into law school, much less graduate and pass the bar exam. Law students take a range of different legal courses, each instructing the lawyers-to-be how to research carefully, think logically, and identify errors in thought. Sometimes the teaching does so directly. One of our courses was called Research and Writing. Other times, the new skill set underlies the legal rulings or rules of law you learn. For example, a law school evidence class is typically based on the federal rules of evidence. You learn what is hearsay and why it is generally excluded from evidence. You also learn what hearsay is admissible, the exceptions to the hearsay rule that are deemed credible enough for consideration. Those rules are the culmination of Western thought on how to discern relevant, careful evidence suitable for proving guilt or innocence with enough confidence to take someone's life, liberty, or property. The rules of evidence are based on logic. The rules include logical determinations of whether evidence is relevant or irrelevant to an argument. There are rules that inspect and ensure the authenticity of evidence. In addition to the actual rules, students read and learn cases where courts have interpreted those rules. These case decisions become additional laws that guide other courts. For example, the Supreme Court set up guidelines for when opinion testimony meets the necessary academic and logical rigors to validate its usage. In a trial, lawyers use those rules to present disputes to juries and other tribunals for findings of fact. Successful trial lawyers must be adept at identifying arguments that do not meet the necessary logical rigors for consideration. This is what frequently makes the television and movies, as a lawyer stands up saying something like, "Objection, Your Honor," assumes facts not in evidence. Evidence. Types. In this book, I will discuss the evidence for and against certain beliefs. A lot of non-lawyers speak of evidence, but have a very limited view of it. Evidence in the legal arena is all-encompassing. For example, courts use scientific evidence, which is critical in assessing claims about the material world of science. But scientific evidence is limited in what it can prove. For example, it can never be used to prove a motive or the knowledge of an individual. Yet, motive and knowledge clearly exist, and in certain cases must be proven by evidence. So, courts use evidence of all types, not simply scientific evidence. The key is that the evidence must be credible in the field from which it is offered. These rules of evidence, and the legal system built around these rules, provide the best tools civilization has developed to answer difficult questions about matters past, present, and future. Courts determine things as diverse as whether someone ran a red light, whether spouses love each other, and whether one is likely to need surgical intervention years down the road. Sometimes there is direct evidence for the matters being proven. By this, courts mean there is an eyewitness who can testify to the matter based on personal knowledge. This is the person who says, "Donnie Driver ran the red light. I know this because I saw him driving a car through the light at a time where I could also see his light was red." Often, scientific evidence is direct evidence. If I want to prove benzene is in drinking water, there is a conclusive test for that. However, even scientific evidence is frequently open to interpretation. Most of the time, however, cases don't have much direct testimony. Most times,